Another consideration is that the plan must continue to maintain its qualified status. You don't want to do anything that's going to disrupt the plan and cause it to be potentially in a qualification breach. So you must maintain your fiduciary behavior as if it were active. Also, full vesting is not automatically required if a plan is frozen, but participants will continue to accrue their years of vesting service. In addition, a freeze can be semi-disruptive to participants as a consideration and in the M&A context, as they may now have two plans, frozen acquired plan and the seller's plan, and then the buyer's plan would say may be eligible for it. And lastly, once again, in the M&A context, the buyer acquires all potential risk and liability of the frozen plan. Okay, so the fiduciary liability carries over to the fiduciary liability of the successor plan and the fiduciaries who were charged with responsibility for the frozen plan as well. Let's define what a plan merger is, a transfer or a spinoff. A merger or a consolidation occurs when assets of two or more plans are combined to form one remaining successor plan. A plan merger is the typical option selected if the buyer's strategy is to provide the same benefits to all employees and has had time to conduct satisfactory due diligence on the acquired plan. So that is fiduciary due diligence. The buyer must be careful to preserve any protected benefits, rights, and features, including but not limited to early retirement options and any optional forms of benefit. There is such a thing as protected benefits. We'll talk about that. A transfer assets occurs when there's a reduction of assets by one plan and the acquisition of those same assets by another plan. That's another aspect of the definition of it in case a transfer. Lastly, we've talked about merger. We talked about definition of transfer, now the definition of spinoff. A spinoff is the splitting of a single plan into two or more plans sponsored by the same or potentially unrelated employers. Now I mentioned this term called protected benefits, and you can find detail on what protected benefits are in IRS code 411 D6. But basically, it's always considered an essential practice, not just a best practice, but as an essential practice to conduct a protected benefits analysis at point of assumption of a plan to assure and identify that these benefits are treated correctly. And when I say treated correctly, I mean these protected benefits have to be first carried over into the successor plan, and they have to be able to be administered by the successor plan's administrator. So those two items have to be considered. What are those benefits that have to be protected in the event of a plan merger? One is early retirement benefits. So if an employee was eligible for early retirement benefits under the seller's plan, that has to be captured under the buyer's plan, as well as those employees that are coming over as a result of the merger. Retirement type subsidiaries and optional forms of benefits, annuitization, installments, and whatever that may be. Further on the distribution forms of benefits, they do include payment schedules, timing of payments, commencements of payments or benefits, types of distributions, in cash or in kind, and election rights with respect to optional forms of distribution. Although recent regulations allow for elimination of and consolidation of optional forms of distribution if certain specified conditions are met. But you want to research that at the point of merger to see if the plan is eligible and you can meet these specified conditions.